The subcommittee will come to order. Without objection, the chair is authorized to declare recesses of the subcommittee at any time. We welcome everyone to this afternoon's oversight hearing on the administration of bail by state and federal courts, a call for reform. I will now recognize myself for an opening statement. Today, the Subcommittee on Crime, Terrorism, and Homeland Security meets to discuss the important issue of bail reform. The national dialogue on reforming bail in the pretrial system, both on the state and federal level, has not waited for congressional attention. There has been a groundswell of community action that has resoundingly proclaimed that the current system is unjust, unfair, and does not work to protect communities. Since 2000, 95% of the growth in the jail population has consisted of pretrial detainees. This increase has had a profound impact on communities. That burden has been disproportionately placed on the shoulders of communities of color. Studies show that low-income and African-American communities are disproportionately impacted during the pretrial phase of the criminal justice process. One such study found that when compared to white men charged with the same crime and with the same criminal history, African-American men have bail set in amounts that are 35% higher. For Latino men, bail is set at 19% higher than it is for white individuals. These defendants who cannot afford bond receive harsher case outcomes and are 3 to 4 times more likely to receive a sentence to jail or prison, and their sentences are 2 to 3 times longer. The situations for defendants who are women is particularly troubling. While women are more likely to be granted release on their own recognizance, they are much less likely to be able to afford bail when it is ordered. 80% of women who are locked up pre-trial are mothers. When mothers are jailed, the families potentially collapse. Their children are more likely to end up with relatives or be subjected to the foster care system. Using financial considerations as the deciding factor of whether an individual is freed or imprisoned perpetuates existing inequities. In fixed money bail system, wealthy defendants who pose a risk to public safety are in a sense able to buy their freedom. The wealthy and the poor receive radically different treatment solely based upon their ability to post bail, which often is set at arbitrary levels well above the means of many people to pay despite the low risk they may actually pose to society. I believe that's patently unfair and is un-American. This hearing offers Congress the opportunity to reshape the dialogue on how the community interacts with the criminal justice system. Reducing pretrial incarceration and the harm associated with unnecessary detention starts with giving law enforcement officers the discretion in deciding at the outset when a case would be better resolved by treatment or services. Those with mental health or substance use issues need not enter the criminal justice system unless they propose a clear danger. In the same vein, providing officers the ability to issue citations in lieu of arrest reduces time spent on low-level cases. According to the International Association of Chiefs of Police, issuing a citation takes less than a third of the time as processing an arrest. These types of reforms put officers back on the street to address violent crime. The nation has reached an inflection point on bail reform. We must examine and pursue alternatives to money bail. The states, including my home state of California, have experienced challenges in reforming their system, and we learn from what has worked and what still needs to be improved. Our discussion today can help both at the state and federal level. Our bail and pretrial systems must be reformed. I look forward to hearing from each of the witnesses as we initiate this dialogue in the Judiciary Committee. It's now my pleasure to recognize the ranking member of the subcommittee.
Thank you, Madam Chair, and thank you to the witnesses that are here today. The use of bail has been part of our legal system since the founding of our country. Our founding fathers included in the 8th Amendment to the Constitution a prohibition on excessive bail. They did not include an outright prohibition on bail, but the 8th Amendment acknowledges that in some cases, a particular amount set for bail may be unconstitutional. As many of us already know, bail is simply used to increase the chances that the accused would return to court if they are released prior to trial. Of course, any deprivation of a person's liberty should be scrutinized. The presumption of innocence forms the bedrock of our criminal justice system. A person's race, gender, religion, national origin, or political beliefs should have no bearing on that presumption of innocence. Our responsibility as members of Congress, as members of the Judiciary Committee, is to explore the different approaches that have been discussed and in good faith identify what works and what doesn't. In Texas has grappled with this very issue. On Thanksgiving Day 2017, Texas State Trooper Damon Allen was killed during a traffic stop. The man accused of killing Damon Allen had been released several months before on a $15,000 bail. In response, Governor Greg Abbott proposed reforms that would require judges to set bail based on whether the accused is a threat to law enforcement. The Chief Justice of the Texas Supreme Court, Martin Hike, announced his support of the governor's proposal. California has dealt with the issue of bail in the criminal justice system. In 2018, then California Governor Jerry Brown signed into law Senate Bill 10, which would effectively end cash bail. As states like Texas and California and others around the country examine these issues based on the feedback state lawmakers receive from their constituents, Congress has also advanced efforts to reform bail practices. In 1966, Congress enacted the Bail Reform Act, which directed judges to release all non-capital case defendants on their own recognizance, unless doing so would be inadequate to assure their appearance. This law did not allow judges to consider defendants' potential risk to their community or to public safety. However, in 1984, after examining concerns regarding crimes being committed by those on pretrial release, Congress updated the Bail Reform Act to allow judges to detain particularly dangerous defendants from whom no stringent release conditions would reasonably assure public safety. Congress expressly prohibited using inordinately high financial conditions to detain defendants. In the U.S. v. Salerno, the Supreme Court upheld the constitutionality of the Bail Reform Act of 1984, holding that the law was constitutional because when the government's interest in protecting the community outweighs individual liberty, pretrial detention can be, quote, a potential solution to a pressing societal problem. As we move forward, we can learn from the history of bail and its use in the criminal justice system. The whole point of our criminal justice system is to protect the public, while ensuring that the accused is innocent until proven guilty and that they are afforded due process. I fear that proposals that would eliminate the use of cash bail in its entirety, however well-intentioned, will fail to take into the account the importance of public safety, will reduce flexibility and discretion for law enforcement, prosecutors and judges, and simply ignore the voices of victims harmed in alleged crimes. Judges use cash bail as a way to protect victims to prevent high-risk defendants from having contact with a victim or witness before trial. Imagine telling a survivor of domestic violence or sexual assault that cash bail is unfair or discriminatory to their alleged abuser. We owe it to these victims and the communities that we all represent to be forthright and honest about these issues and to always ensure that we are promoting public safety. I yield back.
I'm now pleased to recognize the chairman of the full committee, the gentleman from New York, Nadler, for his opening statement.
Thank you, Madam Chair. I thank this subcommittee chair, Representative Karen Bass, for conducting this hearing on the important topic of bail reform. On any given day, 6 out of 10 people in federal and state jails, accounting for nearly 500,000 people, are incarcerated awaiting trial. These are members of our community who are still innocent in the eyes of the law and may in fact never be found guilty of anything. Yet they may spend months behind bars before even having the opportunity to contest the charges against them. The modern bail system has become unmoored from its original intent, which was only to ensure defendants return to court. The current system detains many people based solely on their inability to afford money bail, which results in serious problems for defendants of limited means. It also imperils the effective operation of the adversarial system of justice, and it may even endanger the community. The nearly 500,000 people incarcerated pre-trial are at a disadvantage from the outset. Access to counsel while incarcerated pre-trial may be hampered, undermining preparation of a defense and accumulation of evidence. These challenges, in turn, may unjustly encourage defendants to take plea bargains for crimes that they never committed. Defendants who cannot afford bail receive harsher case outcomes on average than those who are able to pay. They are 3 to 4 times more likely to receive a jail or prison sentence, and the sentences are likely to be 2 to 3 times longer. In addition, opportunities for pretrial diversion programs, which address underlying factors that contribute to criminal behavior, may be unavailable to those who are incarcerated pretrial. Money bail systems challenge the very legitimacy of our criminal justice system and its presumption of innocence before trial. A number of studies on money bail show that it is not even effective at mitigating the risk of non-appearance, while resulting in significant negative outcomes. Now is the time to investigate in earnest alternatives that promote rehabilitation and safety. Unnecessary pretrial detention has real consequences for families and communities. Being detained pretrial, even for a short period, can be daunting. For example, while in jail pretrial, defendants risk losing their jobs and their homes, which can have a cascading effect on families. People who have lost their jobs because of being detained lose income and their ability to maintain their families, placing them at greater risk of engaging in crime. In fact, studies have shown that defendants detained just 3 days in jail are more likely to be arrested on new charges. Unfortunately, the current money-based system promotes release of some of the most dangerous defendants because they can afford to post bond, then with little to no meaningful supervision. And keeping presumptively innocent people in jail is expensive. Local communities spend, by some estimates, $14 billion every year to detain people who have not been convicted of anything. It would be better to redirect these funds instead to crime prevention, rehabilitation of offenders, and assisting victims. In the federal context, the reforms of the past have been proven to be insufficient in balancing a defendant's liberty interest and ensuring that the communities remain safe. At the time of the passage of the Bail Reform Act of 1984, 81% of defendants were released pre-trial, just before that law was enacted. Since enactment of the 1984 Act, release rates have steeply declined, falling to 66% by 1997, 37% by 2006, and 25% in 2018, compared again to 81% 35 years ago. Even release rates of low-risk defendants have decreased. Surely community safety does not justify this trend. A number of states have implemented reforms of their bail systems in recent years, including recently my own state of New York, and the time has come for Congress to examine how federal courts administer pretrial bail as well. Conservatively, it costs upwards of $85 a day to incarcerate a person pretrial. Pretrial supervision, coupled with measures such as court date reminder programs, costs just a fraction of that. Congress should investigate the effectiveness of these practices and other potential reforms. As we consider alternatives to money bail, however, we must determine whether certain alternatives, such as over-reliance on risk assessment tools, may generate additional negative consequences, such as compounding the racial bias that already exists in other aspects of our criminal justice system. While developing effective and just alternatives to current money bail practices will undoubtedly require financial commitment, the cost of inaction to defendants, their families, and the larger community is much higher. The negative impact on every one of even a few days spent in jail pre-trial may greatly outweigh the perceived benefit. I look forward to the discussion today of these very important issues, and I again thank Subcommittee Chair Bass for conducting this hearing. I yield back the balance of my time.
We welcome our witnesses and thank them for participating in today's hearing. Now, if you would please rise, I will begin by swearing you in. Raise your right hand. Do you swear or affirm under penalty of perjury that the testimony you're about to give is true and correct to the best of your knowledge, information, and belief, so help you God? Thank you. Let the record show the witnesses answered in the affirmative. We will now proceed with witness introductions. Brandon Buskey is the Deputy Director for Smart Justice Litigation at the ACLU Criminal Law Reform Project. His work focuses on reforming pretrial justice, expanding the right to counsel, juvenile sentencing, and residency restrictions for former sexual offenders. Prior to the ACLU, Brandon worked at the Equal Justice Initiative and the Civil Rights Bureau of the New York State Attorney General's Office. He is a 2006 graduate of New York University Law School. Following law school, he clerked for the Honorable Janet C. Hall of the U.S. District Court for the District of Connecticut. Shelton McElroy is the National Director of Strategic Partnerships of the Bail Project. Before assuming his current position, he worked at Parent Advocacy and Participatory Defense in Louisville, Kentucky, assisting parents in the reunification process with their children. He is formerly incarcerated individual who was a ward of the state in foster care for over 15 years. Additionally, he was a Just Leadership Fellow and a 2018 BME Genius Award recipient. Mr. McElroy holds a master's in mental health counseling and documentary studies at Duke University. Allison Siegler is a clinical professor of law and the founder and director of the Federal Criminal Justice Clinic at the University of Chicago Law School. She was previously a staff attorney with the Federal Defender Program in Chicago, a Pretty Man Fellow at Georgetown University Law Center's Criminal Justice Clinic, and a law clerk for the U.S. District Judge Robert W. Gettleman. Ms. Sigler graduated magna cum laude from Yale College and earned a JD from Yale Law School and holds a degree from Georgetown. Mary Smith is president of the Ohio Professional Bail Association and serves as the Mid-America Director for the Professional Bail Agents of the United States. For nearly 30 years, she has owned and operated Smith Bonds and Surety in Ohio. She holds a degree in paralegal studies from Ashworth College and licenses in Ohio surety bail, property and casualty, health and life, and a non-resident bail license in Michigan. Kira Cook is a program director for justice reform at the Leadership Conference on Civil and Human Rights. At the Leadership Conference, Ms. Cook leads the development of a federal policy agenda on reform of the criminal justice system for the coalition. Prior to joining the Leadership Conference, Ms. Cook served as a legal fellow at the Open Society Policy Center, focusing on criminal justice, civil, and racial justice reform. Ms. Cook attended Howard University, where she earned a BA in International Business and Management, and Wayne State University Law School. Please note that each of your written statements will be entered into record in its entirety, so accordingly, I ask that you summarize your testimony in 5 minutes. To help you stay within that time, there is a timing light on your table. When the light switches from green to yellow, you have 1 minute to conclude your testimony. When the light turns red, it signals your 5 minutes have expired. Mr. Buskey, you can begin.
Thank you. Chairwoman Bass, Congressman Stubbe, thank you for the opportunity to testify today. Chairman Nadler, thank you for your committee leadership and for joining today's important hearing. My name is Brandon Buskey, and I am the Deputy Director of Smart Justice Litigation at the ACLU. Here are the stakes. We cannot end mass incarceration and its legacy of racial injustice unless we radically reform our pretrial systems. Of the 2.2 million people trapped by the carceral epidemic, nearly 1 out of every 5 is a person locked in a jail cell awaiting trial. Most of these people are in jail because they cannot afford to purchase their release with money bail. Communities of color are uniquely damaged by this system. In response to this crisis, numerous civil rights organizations have brought dozens of lawsuits across the country to end our dependence on money bail. The ACLU successfully brought the first of these challenges in 2014 in Mississippi on behalf of Octavius Burks and Joshua Bassett. Respectively, they spent 10 and 8 months in jail without a lawyer and without even being formally charged with an offense, all because they could not afford bail. Since then, the ACLU has brought over a dozen bail reform lawsuits. Our clients are people like Candace Edwards, who was arrested in Alabama for forging a $75 check. For this, her bail was set at $7,500. When we met Candace the day after her arrest, she told us the night before she had slept on the concrete floor of an overcrowded cell. Candace was 7 months pregnant. In 1987, the Supreme Court in U.S. v. Salerno declared, "In our society, liberty is the norm, and detention prior to or without trial is the carefully limited exception." Today, too many of our criminal court systems have this exactly backwards. Octavius, Josh, and Candace are the norm. Indefinite detention without counsel is the norm. Liberty, sadly, is the arbitrarily denied exception. We must reverse course. The right to pretrial liberty is fundamental. Under Salerno, that means the government can only jail you before trial if it has an exceptional reason. Money is never an exceptional reason. It can delay a person's release by days or even weeks as their family and friends scramble to collect money. In that time, a person may experience many or all of the harms of pretrial detention, such as loss of employment, housing, or custody. This trauma makes them more likely to be rearrested or to miss court. Also, research has repeatedly shown that money is almost always unnecessary. Providing free resources like court reminders or voluntary treatment referrals have proven better at serving the goals of the system to release people quickly, ensure court appearance, and protect public safety. However, ending money bail is not enough. At the ACLU, our vision is a world in which 95% of all people arrested are released within 48 hours. Consider this. Pretrial violence is extremely rare and thus extremely hard to predict. Only 1.9% of people arrested for felonies are rearrested for violent offenses prior to trial. If we truly value the presumption of innocence, how many people can we detain to avoid a risk that happens in less than 2% of serious cases and less than 1% overall? Especially when our methods of prediction, either by a judge alone or with the aid of a risk assessment, reliably reproduce the racial disparities that infect our entire system of criminal enforcement. If we stay true to our values, our vision is achievable. I want to suggest 3 things the Congress can do, in addition to ending money bail, to significantly increase pretrial release and racial equity, all while keeping communities safe. First, increase mandatory and presumptive release. This also means eliminating existing presumptions of pretrial detention, reserving incarceration for rare and very serious offenses. Those who are not immediately released must receive individualized hearings with counsel at which detention is prohibited unless the government proves that it is absolutely necessary. Second, invest in evidence-based reforms that work, like court date reminders. Most people do not flee, they forget. Text message reminders and improved court notices significantly increase court attendance. Finally, set clear goals for risk assessments, then evaluate whether they are working. To be clear, the ACLU opposes the use of risk assessments to determine pretrial liberty. However, jurisdictions using them must ensure that the tools actually result in releasing more people and reducing racial bias. Thank you.
Thank you, Mr. McElroy.
Thank you. In thinking about waiting for criminal justice reform, I think about a story of a friend of mine that had gotten out of prison prior to me. And upon release, he had gone through his belongings that he had had 10 years prior, and he found a ticket to a shoe repair store that had been in his wallet over 10 years. And a day or so after being home, he went and he took that ticket to that shoe store, and he was a little nervous, but he handed it to the cobbler, and the cobbler went in the back and it rustled around for a pretty considerable amount of time and came back out, and he said, they'll be ready in a week. And so that delay that we have in waiting for reform is very similar, that we've been waiting and waiting and waiting, and while we wait, hundreds and thousands of people are held in pretrial incarceration this very day. People that are not guilty, people with the presumption of innocence, sit in jail and will be there throughout the holidays. At 18 years old, after spending 15 of my years in foster care, less than 4 months later, I was sitting in jail during the holidays. My crime was burglary. I had went into a home of someone I knew, and I was hungry. And I started to eat out of the refrigerator and drank. And they came home. And I ran out the back door. I was apprehended shortly thereafter. And, I found myself sitting in jail my whole life, right in front of me. And I had been in institutions my whole life, but nothing had prepared me for sitting in jail at this age. My foster mother, Virginia Rogers, was still living at the time, and I called her, the phone call itself costing $5.65, and on a fixed income was far greater than she could afford. And I told her the amount of my bail, and she told me to hold on to God's unchanging hand. And that I did. Shortly thereafter, I was visited by 2 church members that made me aware that my foster mother, Virginia, had passed. And I asked when the funeral was, and they said it had already passed as well. The charge I was charged with held 1 to 5 years. And the prosecutor proposed a deal to me to take 4 years. I could not balance that responsibility at that age and at that time as to what I should do. I know that I wanted to be a soldier. I had spent time at Fort Knox in a foster home and had gone to sleep listening to the tanks as they fired, and that was my dream. I had taken the ASVAB, and 2 military reps were in the room and proposed to the judge to allow me to go and join, and the judge denied that. Hindsight being 2020, I regret the day I violated the homeowner's space and unlawfully entered their property. Yet today I know that my imprisonment, spurred on by my inability to pay cash bail and defend myself adequately, benefited no one and ultimately cost taxpayers more than $35,000 a year during the time that I should have been in college. The collateral consequences of cash bail, especially on communities of color, can be devastating. I met a young lady named Nisha. Nisha had been accused of hitting her boyfriend. She was arrested on a Friday. $50,000 bail was set. Her mother came up with $1,500, paid the down payment, and Nisha was released with a commitment to pay $300 a month. The following Monday, the case was dismissed, but her debtor's prison never went away. While riding with Nisha, she still owed $1,700. The bail bondsman called harassing her, even offered a deal that if she paid $1,000 immediately, they would relinquish the debt. She didn't have $1,000 to pay immediately. They wanted to download apps on her phone to surveil her. They criticized her because she didn't have a voicemail set up on her phone. Cash bail is unjust. Taking away the presumption of innocence from anyone is unjust. And when we do this and we claim that we're doing this for public safety, we forget that even I was raped. When we talk about protecting the people that were harmed, the large majority of people that come into contact in these situations actually have trauma, and they need healing, and they need reinvestment in those resources to heal. Thank you.
Chairwoman Bass, ranking member, committee members, thank you for the opportunity to speak here today. My name is Allison Siegler, and I'm the director of the Federal Criminal Justice Clinic at the University of Chicago Law School. I'm here today because the federal pretrial detention system is in crisis, and I believe Congress should intervene and fix the Bail Reform Act of 1984. Today, the federal pretrial detention system detains people at an astronomical rate. The percentage of defendants who are detained pending trial has increased from 19% in 1985 to fully 75% in 2018. But that was never what Congress intended. The act was supposed to detain just a narrow set of people, people who are highly dangerous or posed a high risk of absconding. But in practice, pretrial detention is now the norm, not the exception, even though our Constitution says that every detainee is presumed innocent. This skyrocketing federal pretrial detention rate is problematic for several reasons. Studies show that pretrial detention actually makes society less safe because it increases a detainee's risk of recidivism. This is very salient in the federal system because most federal defendants are not violent. Violent offenders make up just 2% of those arrested for federal crimes. The data also shows that the vast majority of federal defendants appear in court and don't reoffend while they're on bond. In 2018, 98% of federal defendants nationwide did not commit new crimes on bond, and 99% appeared for court as required. What's really remarkable about this is that this compliance rate is seen equally in districts that release a whole lot of people and districts that release almost nobody. So when release rates increase, crime and flight do not increase. The high federal detention rate also imposes huge fiscal and human costs. On average, a defendant spends 255 days in pretrial detention, often in deplorable conditions. For example, in the depths of winter last January, pretrial detainees at the Metropolitan Detention Center in Brooklyn, New York, went without heat and electricity for days. While defendants sit in jail awaiting trial, they can lose their jobs, their homes, their health, even their children. And federal pretrial detention imposes a high burden on taxpayers. It costs approximately $32,000 a year to incarcerate a defendant and only $4,000 to supervise them on release. These problems make clear that the federal pretrial detention system is in crisis and that reform is needed. Today, I want to highlight two crucial fixes to the Federal Bail Reform Act. First, eliminating financial conditions that require people to buy their freedom, and second, modifying the blanket presumptions of detention that limit judicial discretion and unnecessarily lock up low-risk defendants. So first, a primary goal of the act was to end practices that conditioned freedom on someone's ability to pay. But every day in federal courtrooms around the country, judges impose conditions of release that privilege the wealthy. For example, some judges impose bail bonds, other judges require family members to co-sign a bond and document their net worth. At best, this unnecessarily delays release, but at worst, it results in the pretrial detention of indigent defendants. In other districts, indigent defendants are required to pay the costs of their own court-ordered electronic monitoring. Congress should end these injustices by modifying the Bail Reform Act to eliminate financial conditions and truly put rich and poor on equal footing. Turning to my next proposal for reform, the statute contains a rebuttable presumption that puts a thumb on the scale in favor of detention in many, many federal cases. This presumption of detention must be changed. It's had far-reaching consequences and very devastating ones. So first, the problem is the presumptions sweep too broadly. They detain low-risk offenders, and they fail to accurately predict who's going to reoffend and who's going to abscond from court. In fact, a federal government study found that the presumptions are actually driving the high federal detention rate. This study had a real-world impact. It led Chief Justice John Roberts and the Judicial Conference to recommend that Congress significantly limit these presumptions. Certain of the presumptions. Today's hearing gives Congress a real opportunity to act on that recommendation. Second, like mandatory minimum sentences, these presumptions of detention severely constrain judicial discretion. They prevent judges from making individualized determinations on release. Federal judges lament that the presumptions are really tying their hands. Although the presumptions were created with very good intentions, they have failed us in practice. In the words of a government study, the presumptions, and I quote, have, quote, become an almost de facto detention order for almost half of all federal cases and have contributed to a massive increase in the federal pretrial detention rate with all of the social and economic costs associated with high rates of incarceration, end quote. I urge you to take action and to bring the federal pretrial system back in line with Congress's intent. Thank you, and I look forward to your questions.
Smith?
Good morning, Madam Chairwoman Bass and committee members. My name is Mary Frances Smith. I'm the president of the Ohio Professional Bail Association, and I thank you for allowing me to testify today on this very important issue. The bail reform movement is not about reform. It is about elimination of monetary bail because of a mistaken belief that it is somehow discriminating against the poor. Currently, most accused persons take advantage of the taxpayer-funded pretrial release program. They walk out of jail on a signature or promise to return to court. However, if a judge sets monetary bail as a requirement, the accused turns to friends, family, or they can employ the services of a bail agent. Bond is set because the accused may have numerous failures to appear. Bond may not be posted because the family might demand that they be kept in jail because that is the only way to ensure sobriety or stop the defendant from reoffending. Many people, including myself, have lost relatives who got released and overdosed within hours. We tried to have them kept in jail so that we could set up rehab for them, but the system insisted on releasing them with no monetary bail, despite repeated warnings from families and friends that they could kill themselves or others. In the criminal justice system, lives are at stake. We have to rely on what works. Commercial bail works. The failure to appear rate for commercial surety is below 2%. When pretrial release programs have a defendant fail to appear and a warrant or capias is issued, local law enforcement attempts to serve that warrant. However, when a surety bond is placed with the court, the surety agent becomes responsible for the apprehension and returning the fugitive back before the court. If the surety does not return the fugitive, it must pay the bond. Without any judicial involvement, I repeat, without any judicial involvement, my nephew Brent was released through a county risk assessment tool that had determined that his risk for failure to appear was 5 out of 6. Within 48 hours of his release, he was dead due to another overdose. The case was dismissed, and because of the way the county counts and labels its results, Brent was listed as a success because his case was dismissed. Judges have used their experience and wisdom to make determinations on who will be released on an own recognizance bond, who should be detained until trial, and who should be offered bail. The bail reform movement is replacing judicial discretion with risk assessments. Most risk assessments are a brief list of 7 to 9 questions that ask things like, have you ever been arrested before? Many accused will not offer honest answers. An algorithm can never replace the wisdom of a judge's discretion in deciding who should and should not be released awaiting trial on bail. The issue here is there is no accountability for pretrial release programs. How much federal money is being spent on pretrial at the state level through the Burn J grants? How many accused are funded through taxpayer dollars that have failed to appear? How many of the accused released on pretrial have a history of violent crime? No one knows because Congress doesn't require the states to report. And we have these pretrial programs that are not accountable being heralded as a magic solution for bail elimination. How can we support any bill that penalizes any state that allows monetary bail as an option to the court? Citizens have a right to know if their tax dollars are being used effectively or are being used to prop up a failed system of revolving jailhouse doors that have no accountability. Let's take an honest look at pretrial programs and lay them side by side against commercial bail. Let's compare the failure to appear rates. While bail reform sounds noble, let's look under the hood. Find the data needed to examine pretrial, but allow judges to continue using their discretion and determine bail with the facts before them on a case-by-case basis. I thank you.
Ms. Cook?
Chair Bass, Chair Nadler, and Ranking Member Gohmert, and members of the committee. Thank you for the opportunity to testify about the need for meaningful bail reform in state and federal court systems, including the need to eliminate cash bail and reduce pretrial incarceration without the use of algorithmic-based risk assessment tools. We commend the subcommittee for focusing on the failures of our current state and federal pretrial systems. These systems are not serving their original purpose, to ensure people show up to court. Instead, they fly in the face of a foundational constitutional principle. One is innocent until proven guilty. They also heavily rely on money bail for determining who can and cannot go home while awaiting trial. This has created a two-tiered legal system, one where poor people are detained pretrial because they can't afford bail, and wealthier people can walk free. Pretrial detention is the norm in too many communities. Each year, 12 million people are admitted to jail, and each night, nearly 500,000 people sit in jail awaiting trial. This pervasive system of pretrial detention has devastating effects, especially on Black and brown people. Stories like those of Sandra Bland and Khalif Browder show the sometimes shocking effects of pretrial detention. Pretrial incarceration increases people's likelihood of conviction and their risk of recidivism. Even a short period of pretrial detention can have cascading effects. People are at risk of losing jobs, homes, medical care, custody, and relationships. There are more effective methods than money bail to ensure court appearances. Pretrial support systems can address the structural barriers that keep people from showing up to court. They can provide child care, transportation services, and other non-punitive or for-pay supports. Even simple steps like providing reminder calls or text messages dramatically reduce rates of failed appearances. Fortunately, places like Washington, D.C., Philadelphia, New York, and New Jersey are successfully moving away from money bail and safely reducing their pretrial populations. But in some instances, jurisdictions have adopted undesirable alternatives, namely the use of pretrial assessments. Risk assessments are actuarial tools that use historical data, both from criminal legal databases and demographic factors, to attempt to forecast an individual's likelihood of appearance at trial or risk of rearrest. Research has shown, however, that these algorithms reflect current biases within the criminal legal system because they use flawed data, such as prior failures to appear and arrest rates, and as a result are profoundly limited. Champions of these tools argue that they are evidence-based and can provide judges high-quality, objective data that will help them make their jail population smaller without putting the public at risk. But independent studies have shown that many jurisdictions using risk assessments have actually increased pretrial incarceration, and none have reduced racial disparities in pretrial decision-making. A group of data scientists recently wrote in a letter to this committee, I quote, "Pretrial risk assessment tools suffer from serious methodological flaws that undermine their accuracy, validity, and effectiveness. Pretrial risk assessments do not guarantee or even increase the likelihood of better pretrial outcomes. The technical problems with these tools cannot be resolved, and their limitations disproportionately impact communities of color." These concerns led the Leadership Conference to publish a statement of concern signed by more than 100 civil rights, data science, and community-based organizations. The statement argued that risk assessment tools were deeply flawed, skewed based on race and socioeconomic status, and therefore should not be used when making detention decisions. We believe that jurisdictions can safely end money bail and release most accused people pretrial without their use. Members of Congress, we need a new pretrial framework, one that dramatically reduces detention, ends racial and other inequities, and abolishes wealth-based discrimination. Federal legislation can help to incentivize states to end money bail, use alternatives to arrest and prosecution for minor offenses, and preserve the presumption of innocence by establishing robust pretrial adversarial processes, hearings, all without the use of risk assessment instruments. We look forward to working with the members of this subcommittee to meet these goals. Thank you.
Thank you. We'll now proceed under the 5-minute rule with questions, and I'll begin by recognizing myself for 5 minutes. The questions I'd like to ask, I want to focus on policy recommendations to understand specifically what you all would recommend. Because saying things like eliminating financial conditions and all, I'd like to understand more about that. I wanted to begin with Mr. Buskey. I saw in your resume you also deal with juveniles, and so maybe you could talk about the differences in terms of juvenile detentions.
In terms of pretrial release, well, I think that for juveniles, well, I should say, as an initial matter, the goal of our pretrial system should be to ensure success and ensure that people are returning to court, ensure that they are not being rearrested. And so that primarily means identifying the proper metrics of support that will help a person succeed once they are released. And so the question of the differences for juveniles is really one of how do we assign the proper resources for a juvenile to ensure their pretrial release. And I'm assuming you mean a juvenile who is in the criminal system. So one that will start with, again, counsel who understands the unique circumstances of a juvenile in that situation, and then other means of support, whether that juvenile is in school, needs treatment perhaps for other issues going on. But just like it is for an adult, the question is, what is the individualized assessment of what that juvenile needs to succeed prior to trial?
And you talked about mandatory release and that the government would need to prove. Could you speak more about that in terms of what your recommendations were?
Absolutely. When I say mandatory release, I'm primarily talking about citations and release or summonses. So this would be a situation where police make an arrest, but that the jurisdiction has defined certain offenses where that person does not need to be booked into the jail. They are simply given a court date and then returned sometime later.
Do you think that there should be an increase in the electronic monitoring?
No. And in fact, that's a major concern of the ACLUs. The monitors are extraordinarily intrusive. They are a search under the Fourth Amendment, and beyond that, there is very little evidence that they actually help to ensure that people return to court or prevent rearrest. So our vision is that those types of liberty-restricting conditions would be subject to very similar types of due process restraints as detention itself, because they come very close to that phenomenon.
Mr. McElroy, what would be your specific policy recommendations?
Yeah, so I think we're both in unison around not using monitoring systems. I give you an analogy of a young man, 17 years old, a youthful offender who our organization posted cash money bail on behalf, and the mother had the responsibility of taking him to check in every Thursday. She worked all day, passed through Long John Silver's drive-through. On returning the following Thursday, he was violated and held in detention because that was a deviance from the path that they were supposed to take. She didn't think it through. She was hungry. And so,
Wait a minute. Say that again.
yeah, so he's on monitoring. He has a weekly check-in on Thursdays to come to the court monitoring office, but there's intrusive restrictions. You go, you come. The monitoring's a GPS system. She pulls in the Long John Silver's drive-through, gets some food from a long day's work, goes home. They go back to check in the following Thursday, and he's incarcerated.
Okay.
Yeah.
So as a minor, I mean, he didn't do that.
No. So there's not a lot of built-in capacity to be flexible. There are numerous clients that are on these monitors working in factories and manufacturing, and the GPS doesn't read they're in the building. The next thing you know, you've got law enforcement at their job arresting them. So and then public transportation, if the monitor is to keep somebody from somebody, the bus happens to drive through the community that they're in, you have a violation as well.
Ms. Sigler, and I just have a few seconds left, so recommendations?
Yes, the two most important reforms are the ones I mentioned.
You're right.
I apologize. The two most important reforms are the ones I mentioned earlier, simply eliminating the presumptions of detention, eliminating financial conditions. If I may address the financial conditions issue, one part of the act tells judges not to impose a financial condition that results in the detention of the person, but there's other parts of the act that cut against this. So there's parts of the act that allow judges to detain somebody simply because the family has no property to post in the sense of a home or no money bail that they can sign for. And in some districts, pretrial services literally recommends that somebody pay for their own electronic monitoring conditions in every single case. So these are serious problems, and I think we need a bright line rule that just prohibits financial conditions.
Thank you. Mr. Gomer?
Thank you. Appreciate all the witnesses being here today and your mental adroitness in adjusting to different ranking members. But I'm not, and I appreciate your insights into the federal system, extremely familiar with Texas state system. When I took a felony bench back January of '93, I was appalled to find that our commercial bailsmen had not had a bail forfeited in years. And so people didn't show up. We started forfeiting bonds. I think they thought that perhaps by donating to my campaign that they would be able to continue, but it'd be like an insurance company accepting premiums and never paying a claim. They got real good at, and I could see they were better than the county system for making sure that people showed up when they were supposed to, because now they had a very substantial financial interest. There are problems with some commercial bail bondsmen who do take advantage of the situation and try to get people to sign up, whether it's their homes, different things that should never be put at risk. So I had concerns about that, and we would try to make sure people knew who were, more ethical and moral. But I have been concerned too over, it seemed like 70s, early 80s in Texas, there was a huge concern about rights of offenders or alleged offenders, and crime rates had gone up, and then that pendulum swung hard the other way for a number of years. Crime rates have gone down, so since I've been in Congress, I've seen much more focus on offenders or alleged offenders' rights than a victim's rights. It didn't seem like race was an issue. It certainly wasn't for me. In bail, it was what kind of crime is alleged to have been committed, what are the risks to the public and specifically victims, and I'm concerned that we are getting away from concern about reoffenses. And it's interesting, Mr. Buskey, to hear you concerned about electronic monitoring. All through the 90s, I constantly was hearing, please let us use electronic monitoring. I understand the invasiveness and the constitutional concerns, but you surely have got to admit it's not as intrusive as being behind bars. And that's why defense attorneys were begging for electronic monitoring. We had to make sure that they weren't gouging people. But I'm a fan of using treatment, not short term, but at least 30 days or so treatment. And I think that's something that should be encouraged, since the majority of people seem to have drug or alcohol problems who come before courts. But I'm very concerned about pushing everybody out without any requirements of bail. Obviously, if somebody's bounced a check, for heaven's sake, they're not a violent risk. That's not something where there ought to be any kind of bail, like had been said. But Mr. McElroy, from the things you've said, my heart goes out to you, not for the offenses you committed and different punishments so much as the fact that you didn't have a loving family home. You were a foster child. I would love to know more about your background, when my time is running out. But I've encouraged, when we were in the majority, we should have hearings on what seems to have more to do with crime in America, and that is the breakdown of the family and every child knowing they were loved and cared about. I would love any submission, but especially from you, Mr. McElroy, from your perspective, if you could write a note and provide any insights you have to what would be helpful in that area. But we appreciate all your time. I wish we had more than 5 minutes. I wish I talked faster so I could use it more effectively. But this is a huge issue, and we appreciate everybody being here. Any comments that any of you would have from your perspective, I just do think we need some kind of bail program, but it doesn't need to be punishing people. It needs to be protecting public more than anything, and encouraging treatment for those that need it. But welcome your insights. You've given us your testimony, but any thoughts, especially based on questions you've heard today, that could be submitted to the committee would be appreciated. Thank you very much.
Mr. Chairman?
Thank you, Madam Chair. Ms. Ziegler, at the federal level, defendants are released pretrial at a significantly lower rate today than they were 20 years ago. We've been through that. I think it was a 25% compared to 80-something% in the 80s. Obviously, this is very concerning. What are the primary reforms that are needed in the federal bail system to address the falling release rates?
So one issue I haven't discussed yet that I think is really important is that we have to limit the crimes that make someone eligible for detention in the very first place. And this is separate from the presumptions of detention. The presumptions apply at the detention hearing, which usually happens a few days later. But the question is, at the outset, at the very beginning of the case, what makes somebody detention eligible? And this is one of the key drivers of these astronomical federal detention rates. The fact that in many federal cases, the judge is just required to lock somebody up as soon as the prosecutor moves for detention. If it's a certain kind of case, then the judge has no wiggle room, the judge's hands are tied, and he or she just has to lock the person up. And that's true in pretty much every single federal drug case without regard to the person's criminal history.
And this was new since the '84 Act?
This is since the '84 Act, exactly.
Before '84, you had more discretion, you had discretion and it was exercised?
Yes, before '84, there was discretion that could be exercised. This is section 3142F of the Act, and it has these 7 specific conditions, most of which are specific types of crimes, drug crimes, gun cases, things like that. But drug cases account for nearly 1/3 of the federal docket. So if you took drug cases off of the list of cases that automatically result in detention at the first appearance, we could have a huge impact on these federal detention rates. Alternatively, you could just make detention at the initial appearance a discretionary decision by the judge. Right now, it's mandatory. If we just gave the judge discretion,
Right now, it's mandatory that the defendant be detained if it's certain...
in certain kinds of cases, yes, it says shall. And if we just change the wording of the act to may, then the judge has discretion, and that's what we want. We want judges to be making these decisions, as many people here have said. So I think, and we want judges, not prosecutors, making that decision. That's the right decision point.
Thank you very much. Mr. McElroy, the collateral consequences of unnecessary pretrial confinement are grave. You've mentioned some. What are the lasting impacts in your experience of being detained pretrial?
Yeah, so, you know, I want to definitely say that people that are impacted by incarceration are resilient, whole, and resourceful, right? So this isn't a story of a deficit. This is a story, in my own personal, of overcoming a system. And it wasn't a lack of family, because it was a system that deteriorated the ability for my mother to provide for me. A system, policy made in this very chamber, that decided that when a child goes into foster care, you had to expedite termination of parental rights. That happened right here when you had the majority, sir. So I want to talk about the system that has fed and fueled mass incarceration, okay? That's why we're here. It's not because communities are weak. It's not because families are weak. And so the residual consequences are that we have Black and brown communities that are decimated by mass incarceration, and it's not slowing down. It's not slowing down. The bail bonds industry makes $2 million off the backs of Black women. That's who pays the bail on behalf of their children, women.
Thank you. Ms. Cook, pretrial risk assessment tools present clear concerns. What alternatives do you think states could implement that protect community safety and ensure defendants return to court without some of the problems of pretrial risk assessment?
So excuse me, we believe that we can increase mandatory and presumptive release with cite and return to court summons. We can also dramatically increase pretrial supports like transportation services, child care services, even the smallest thing like redesigning summons forms so people understand them better and understand when they have to show up to court, as well as text message reminders. All of these things can increase the likelihood that someone will appear for their court date in the future. And public safety, of course, is something that we should be concerned about, but that is the very limited exception. 95%, as Brandon said, of people can be safely released on their own recognizance or with very, very limited.
But on what basis do you determine the 5% or 2% or whatever who cannot without using a risk assessment tool that is problematic?
We know that the majority of people who are detained pretrial today are there, almost 2/3 of them are there for misdemeanors, are there for very low-level offenses. And knowing that gives us some sense of who those folks are and that they can be released pretrial. Many of them are sitting there because they can't afford bail. And so in the limited circumstances where there needs to be a determination of whether someone's conditions should be applied to someone or detention should happen, that has to be done in a robust adversarial hearing process where a person has counsel, where they are able to present witnesses, where there's evidence that is able to support that decision. And then a judge should make that decision, not a risk assessment tool.
Thank you very much. My time has expired. I yield back.
Mr. Gorin?
Thank you, Madam Chair. And, thank the witnesses for being here as well. As a former prosecutor at the local level in Virginia, I have a perspective on bond that is a little different from the federal perspective, but a lot of things are similar. I'm intrigued by Ms. Siegler's statement about no bail for certain offenses. You're talking about presumption cases, right? Presumption against bond in certain cases, right?
So, yes. There are two places where this is a problem. Yes, at the detention.
Not a problem. I'm just trying to clarify your statement.
Yes.
You said there are certain offenses for which there is no bond, and I don't think that's accurate.
Oh, no, I didn't mean to say that. I apologize. What I meant was there are certain offenses for which, when at the very first appearance, the judge must detain the person until a detention hearing, which is usually 3 days later.
Okay.
And that was the point I was talking to Mr. Nadler
Thank you for
about.
clarifying that. Okay. But there are a number of presumption cases on the books, just as there are at the state level. It seems to be growing in number, for which it's up to the future defendant to have to prove to overcome that presumption against bail. And I think that whether it's at the federal level or at the state level, what we're seeing is an effort to box in and tie hands and limit options, whether it's for judges, whether it's for prosecutors, because they're involved in the bail process too. And a lot of times it's done up at the judge's bench, especially at the local level, first thing in the morning. You have a probation officer there, the individual's there, they're appointed an attorney, they can set a bond hearing for the attorney to represent them, but at that point, they don't have anybody right there. And so really it is a conversation that's going on. So whether we're talking about presumptions on the one end or mandatory release options, which is being talked about, I think you're tying the hands on both ends of the spectrum. And we need to leave as much discretion as possible to the judges who are evaluating the factors at stake here, whether the individual is going to be a danger to the community if released, whether the individual is going to be a flight risk, what that criminal history shows regarding failures to appear. If there are failures to appear on the record, a judge is going to not want to have another failure to appear on their record when they don't show up the next time, for whatever reason that occurs, whether it's a financial reason or whether it's some reason related to the person's work situation, family situation. These things will come out in the process if the judge is given the discretion to look into it, and if the probation officer and the prosecutor are given the opportunity to craft something that's right for that individual. So I don't think pretrial is a replacement for bail. I think the two can work together. And I don't think removing all financial factors from this process is possible or appropriate. At the end of the day, I think you need a combination of things, but long and short of it, you really do need to maintain that flexibility at the local level. And I'm sure that some of that will apply to the federal system. I'm a freshman, so I'm just getting into the federal system, but I think there can be some accommodation for both. Ms. Smith, is there anything else that was mentioned that you might want to address?
Yes, thank you, sir. I want to address Mr. McElroy. My mother was a foster mother for 21 children, along with the 8 of her own, so I understand the foster care program very well. But I want to explain that you came from Kentucky. When you were arrested, when he was arrested in Kentucky, there was no commercial bail allowed. There still is not. Had there been a commercial bondsman in the area, and had you called collect on that phone to the commercial bondsman, we would have worked with your family to secure your release, and monitors wouldn't have been held, you wouldn't have been held in jail. We do a very good job of releasing people from the jail cell very quickly. We offer payment plans in almost every state in the United States. Illinois is another state that doesn't allow a commercial bail. Monetary bail does work, but most of the time it works well when you have a commercial bondsman who will post that bond. To answer your question about a bondsman who threatened, 31 years and 40 agents later, we have never threatened our defendants or their families. We make sure that they show up. We call them before every court date. I apologize, ma'am. Thank you.
No, it's okay. Thank you. Ms. Jackson-Lee?
Thank you so very much, and thank you for holding this hearing. Let me try to untangle and unweave, if there is that word with quotes, this system of bail and really label it in the context of chattel. It's as if you are holding chattel in the old days and bartering and bargaining. They're coming and going. And so I think in the innovative thinking of what we should be doing on the federal level, it is to detangle and disengage from a bail system for this nation. And I certainly respect all industries. The bail system is an industry, and certainly income is generated from it. The question is whether the harm is too great and that the federal system needs to take charge of this so that it is not this disparate state, complex maze that families have to work their way through. And that is the context in which I'm going to ask my questions. First of all, let me read into the record and ask unanimous consent to place an article by Cameron Langford and read exactly these words from Houston, Texas. Texas' most populous county unconstitutionally jails poor people charged with misdemeanors only because they cannot afford a pretrial detention system that also violates state law or federal judge rules. Lead plaintiff Miranda O'Donnell sued Harris County in May 2016 after she was arrested on a misdemeanor charge of driving with an invalid license, and a magistrate in an obscene decision set her bail at $2,500. O'Donnell, 23, says her detention jeopardized a new restaurant job she was depending on to care for her young daughter. She got out of jail after a few days by mustering support to get the $2,500. And so I'd ask unanimous consent for that to be put into the record. And the headline says that the federal judge strikes down the Houston area bail system. It's 2019, and we're still in the midst of negotiating that settlement because of the major opposition that occurred on that particular action by the federal court, who was really appalled and just recently held an open hearing for those who are for and against to come and speak about it. So I think it is clear that this should be handled from the federal level. Let me thank you, Commissioner Rodney Ellis, Judge Hidalgo, and Commissioner Adrian Garcia, who are at the cornerstone. Let me ask you, Ms. Sigler, on the question of your point about Congress, this whole idea of a flight risk, and this whole idea of, I probably take issue with only a small minority of defendants to be detained, and I think I know your point, but how is this issue of dangerousness really biased courts heavily toward ensuring African Americans are not released or they get a very high bail because of stereotypes of our community persons being more dangerous than others? And let me ask this other question so I can get in within the time. I've introduced legislation and intend to be engaged in sort of an omnibus approach to juvenile justice, and that is the horrific bail system that Caliph, the young juvenile out of New York that was in Rikers Island, that I think is a historic case, and remained incarcerated for over a year without even counsel to the and because of the family's circumstances, it is painful, and of course, ultimately, he lost his life, not incarcerated. So those 2 points, if you could answer, how dangerousness biases the decision in bail systems, and 2, the unfair system that deals with juveniles, where it is an uneven landscape across America.
On the issue of dangerousness and the race connection, in the federal system, I don't have the data or the stats specifically for how that works, but I do know that our federal system is the vast majority of defendants are Black and brown, are people of color, and we are detaining so many people, huge numbers of people in drug cases where almost everybody is a person of color.
So can I go quickly to Mr.
Yes.
Buskey, who's seen cases across the nation, how the element of dangerousness impacts people of color in making determinations about bail?
Absolutely, and I think Chairwoman Bass, in her comments this morning, said that bail is often set at 35% higher for African Americans for the same offense. And what we learn is that in many systems where they are using money bail, even though it itself cannot mitigate a risk of danger, that judges are using bail to surreptitiously address danger, and that's part of why African American bail amounts are higher.
Do you want to comment on Caleb, juvenile bail?
Cliff Browder, yes. Yeah, I think it's a perfect example. Individual comes in, an offense that does not signal any type of dangerousness. The judge sets bail reflexively. This is very young man, very subject to abuse and worse at Rikers Island, and just severely damaged him coming out, even though he was completely innocent of the charges. And we have to keep that in mind, the sort of trauma that people go through when they are put in prison, especially when they are very young and are placed in that environment.
Mr. Richmond?
Thank you.
Thank you, Madam Chairwoman. Look, I'll try to go fast. Part of this is trying to understand and coordinate everything people at the table are saying, because some of it's inconsistent. And I don't know how many of you were actually criminal defense attorneys, but I did that. So when you talk about, for example, Ms. Cook, you talked about judicial discretion, and so did you, Ms. Ziegler. I'm not a big fan of judicial discretion unfettered. Every elected judge in the country is scared of a Willie Horton moment. So if you abolish cash bail, and now we put more into judicial discretion, Tyrone and Leroy are going to be less likely for a judge to take a chance on them than William or Billy. And so when we see that in the system, that's what kind of concerns me. So, Ms. Cook, you all quoted Vera, who does risk assessments in my home city. Where do you fall on the risk assessment?
So the Leadership Conference, as I stated before, issued a statement of concerns around risk assessment, and primarily because we found that these tools were being cast as being very objective, but in reality, they reflect the biases within the criminal legal system along race and socioeconomic status. And because of that, they are extremely limited in being able to forecast or predict the likelihood that someone would be rearrested or fail to appear in the future. It's solely based on the data that is put in the system. So garbage in data.
Garbage out.
Garbage out.
Thank you. The system has to be reformed. But what I don't hear us talking about at the table is if an offense is likely probatable and the person is likely going to receive probation, then they ought not be held at all, because the chances are if they plead guilty the next day, they would not serve a day in jail. So I don't hear anyone talking about more of a focus on issuing summonses as opposed to the arrest in the first place. We ought to look at what crimes we should be issuing a flat summons for to appear to court, and then anything that is likely probatable. It doesn't make sense to risk the incarceration, the collateral damage of just that weekend in jail. So I would love to talk more about that. Mr. Buskey, ACLU, California, what's the status of that? I know you all supported ending cash bail. There's a referendum now. Where do you all stand on the complete elimination of cash bail?
As far as SB 10, we opposed SB 10 as it was passed. That is now on the referendum, is also before the California Supreme Court. We do believe that we have to end cash bail, but as I said before, we also have to go much farther, and I would echo your concerns about finding ways to automatically take certain kinds of charges out of the detention net. And so an increase in diversion, an increase in citations instead of arrests, summonses, would be completely in line with our vision of how to dramatically increase release rates in the country.
I think that at some point we have to convene everybody at the table and have a real honest conversation, because when you start talking about judicial discretion, let me go to the most unpopular thing that people in the criminal justice reform movement talk about, which is the 94 crime bill. People talk about how it led to mass incarceration, but they also say in the same breath that diversion is a great program. Diversion was in the 94 crime bill. People talk about how drug courts are a great progressive way now, but that was in the 94 crime bill. What we saw was that judges were unlikely to sentence African-American offenders to drug courts because they were scared of their William Horton moment. Prosecutors were scared to recommend diversion for African-American defendants because they were scared of their Willie Horton moment. So in a system that has so many judges are elected, so many have to come up for reaffirmation, that they are scared to take chances on people they don't understand or know, or communities they don't come from. And I think that if we don't address that part of this, we're going to have a problem. And then it shows up in the cash bail system where you set these Willie high ones. Real quick, and Ms. Cook, you cite the Khalif case. Mm-hmm. That was judicial discretion. Because he had a probation hold, the judge would not even let him get a commercial bond. And so holding him on a probation hold or a parole hold on the theft of a backpack defies common sense from the beginning. So I just want to make sure that I don't believe judicial discretion, for the most part, the way judges have exercised that, may be the answer also, because they are scared of things they don't understand. And many white judges don't understand young African-American males, the neighborhoods they come from, or the collateral consequences of one day of incarceration. So I really think, and I want to thank the chairwoman for bringing us together, because I really think we have a lot more conversation to have on this. But the one thing we all agree on is the system as it is now is absolutely broken.
Thank you. Mr. Reschenthaler?
Thank you, Chairwoman. I appreciate it, and I would yield to my friend and colleague from Texas.
Thank you. Mr. McElroy, sensed in your comment about when you were in the majority, some hostility towards Republicans, but I'm a little taken back. I'm not sure what you're talking about. If there was a federal law that usurped the state parental rights, it terminated parental rights early, because here again, some of you want us to usurp states' rights in state cases, and I know that's been going on for years. We keep taking more and more authority, and that's on both sides of the aisle. I have concerns about that, but I am curious about your background. You don't go into it in your statement, but so why were you ever taken from your mother to begin with?
Thank you for...
Will the gentleman yield for just 1 second?
Okay.
The federal law is, it was great intention. We didn't want kids to linger in foster care, and so essentially the law says is that if you're in foster care for 18 months, that parental rights can be terminated and you can be put up for adoption. So it was well-intended law, but it has had some bad collateral consequences.
I appreciate that, Chair.
And that policy was solidified here. And so when I say that, and I want to make clear, my deceased foster mother, Virginia, is a conservative, and I say is,
Well,
she's deceased. So it's not a
But I'm curious about your original background. Did you have a father at all in the home?
Yeah, so the policy specifically, what it did was, instead of supporting my 14-year-old mother at the time, right? Like by resourcing her, trying to get her through therapy, treat, like that's the power that you wield, right? You can make a decision to punish her, to expedite termination of her custody, or you can make a decision to extend the hearing, resource her, and help to support her and undergird her. And that's the same conversation we're having about
Did your father
incarceration.
provide any help at all to your mother, your 14-year-old mother?
So my father happened to be married at the time, so there was a wedge in that area.
Yeah, definitely.
But I want to really talk about what you all can do to contribute, because it's the same scenario in terms of people that are coming into incarceration. You were a judge, you sat on that bench. The majority of clients you sat and looked at had been traumatized. And that trauma had crystallized and hurt people. And so what we're not talking about here is how to redivert funds in incarcerating pretrial people and start to redivert them into resourcing people, substance abuse, so that people can be prevented from overdosing. Jails are not safe spaces for drug and alcohol abuse. Right, so the pivot is to
I'm
you.
a big fan of diversion for treatment if people serious about getting it. And I appreciate your comment, but you're not going far enough back. You're talking about jail, and I'm wanting to get to the root of the problem.
So the root of the problem, we have a vicious legacy of
don't even
slavery that
recognize the root
men
of
were
the problem
separated from
being
black children and black women day in and day out in this
nurturing,
state.
loving
This
home.
building was
And you
built
won't
off of the
recognize
backs of
that, Mr.
enslaved
McElroy.
Africans.
You want to
That
talk
is
about
the root. If
problem
you want to go to the
jail,
root, let's go to
and
1619.
this is my time, Mr. McElroy.
You're
you
asking
won't
me
recognize
questions.
the fact that you have been traumatized, you have been done wrong through jail, but you won't
Traumatized
recognize
through
that
policy that will
you can
not
answer-
resource
let-
clients.
Let the member ask the question.
Yeah.
You can answer afterwards.
you aren't recognizing what I'm pointing to. Yes, you were traumatized. We need to fix jail problems. We need to fix bail problems. But I want to get kids back to a place where they've got a loving, nurturing home, and they don't have to go to foster care, that they've got somebody there that can take
Redlining kept homes from going to black families, right? Let's talk about the policies that insulated and created this problem.
The breakdown. Hubert Humphrey talked about it beautifully in 1964. He predicted the problems that we have created with the breakdown of the home, and I still
Happened
think
well
we
before
gotta go back.
1964.
Oh yeah, it started before that, but he recognized it
Well
when
before.
others didn't. And my
Thank you. Representative Cicilline?
Thank you, Mr. Chairman. I think one of the challenges is all of the kind of racism and injustice and discrimination that exists in our society plays out in the criminal justice system. We're trying to fix a bunch of stuff that has decades of origin. And I think this struggle, as Mr. Richmond said, between judicial discretion and statutory directives is a challenging one, because judicial discretion only works so long as you have judges who actually are exercising discretion in an appropriate way. So I was a criminal defense lawyer my whole life, and so this idea of letting judges have all this discretion, while it sounds great in theory, I think we have to really think about some guardrails and some guidance. So we have a huge problem here. 1 in 5 individuals who are incarcerated awaiting trial. That ought to shock and alarm everyone in this country. It turns the presumption of innocence on its head. And when you look at the number of people who are incarcerated because they simply can't afford to post bail, that means they are in jail because they're poor, period. There's no other. That is also inconsistent with our basic principles of justice and fairness in this country. And so I think we have a big challenge here, and not an easy problem to fix, but I think we all recognize we've got to do something. So I guess my first question is to Ms. Siegler. Is one way to begin to think about this is maybe to reverse the presumption in 3142. You know, we have a release statute that essentially creates a presumption of detention and puts the burden on the accused. So as a beginning point, maybe if we just eliminated that and said, that the presumption is, unless the judicial officer determines that such release will not reasonably assure the appearance of the person as required or will endanger the safety of any person, the person should be released. In other words, get rid of those set of rebuttable presumptions and then create a category of offenses for which you cannot be detained. And then finally, to the extent that you're going to use any risk assessment, have a mechanism to reveal the economic and racial bias of those assessments so that you can challenge them in a meaningful way. And the example I always use is, if I broke a window as a kid, my mother would likely call the neighbor and say, David, sorry, can we pay for the window and it be repaired? And a young man of color who had the same experience very likely would have the police called and get a juvenile record, and so it begins. So I'm very worried about risk assessment tools, so I'm going to come to you in a moment. But is that something in 3142, is that a way to start to think about some reforms?
Yes, I agree completely with all three of those reforms that you just laid out. Number one, change the initial decision point and give judges discretion rather than just forcing judges to lock people up for certain crimes at the very outset and hold them till a detention hearing. Number two, what you talked about is the presumptions of detention that kick in at the detention hearing. Those are under 3142E. And those are a serious problem for many reasons. And I think the first problem is they sweep way too broadly. So when the statute was first enacted, those drug cases made up like 18% of the federal docket. Now, the rise in drug prosecutions means that these presumptions are applying to a huge number of cases.
Yeah, no, I agree. I just want to be sure I can get in a couple more questions, but sure. Yeah. The other thing is, I think it's an obvious point that I hope everyone who's watching this hearing understands is pretrial detention of people who are awaiting trial has a significant impact on your ability to prepare for trial, your ability to locate witnesses, consult easily with your attorney, the impression that the court has of you as an accused person when you come in from the prison or the jail versus come in from the community, your ability to develop a sentencing program if you in fact are convicted, and your ability to do work in the community to show what you've done. I mean, there's so much research that shows how you end up being sentenced is directly impacted on whether or not you are released pretrial or held pretrial. So it has implications for our system of justice well beyond that individual defendant, but just how the whole system works. And Ms. Cook, I want to ask you, are there risk assessments that you think are particularly good that take into account appropriately the kind of racial bias and economic bias that exists, or are there none that are some that are worse than those that we could at least look at as a guide?
So what we've seen, and I think what research has shown us, is that risk assessment tools are very limited in their ability to account for the racial bias that is sort of baked into the data that the tools are trained on. Yeah. And because of that, you are unable to judge Black or white defendants sort of statistically equally in those tools. And so that is hardly impossible. I mean, it's patently impossible. You could use the risk assessment tool in the opposite, though, right, to say, hey, what is going to be the impact of the person if they are detained pretrial on their life, on their family, on their housing or jobs? They could be used in that regard.
Can I just ask you, Mr. Buskey, one last question? Is it worth thinking about, I know what you said about electronic surveillance, but what about the idea is if a judge orders detention, whatever rubric we develop, that the presumption is that detention occur by way of electronic monitoring, absent some finding that that is insufficient to secure the return of that defendant and the safety of the community. So, in other words, kind of put it down one and say, electronic monitoring is presumptive if it's someone who needs to be in custody, because that's a custodial intrusion, and absent some evidence that that is not sufficient to secure that person's attendance and the safety of the community, the court has to impose electronic monitoring and not require the defendant to pay for it.
The gentleman's time has expired, but you may answer that question.
Very quickly, I think if determined under the appropriate, robust procedures and protections and the proper standard of review, then I think we could consider that proposal. The concern would be simply that the use of monitors would spread far beyond the original intent, and that's the hard thing to really cabin.
Thank you. I yield back. Thank you, Mr. Chairman.
Thank you. I now recognize myself for 5 minutes. Let me first thank the witnesses for being here. I'd like to thank Chairwoman Bass for calling this important hearing and Chairman Nadler for all your important work on this issue. I agree with Congressman Richmond that the pretrial detention system is broken. Right now, we have approximately 450,000 people sitting in jails and prison, even though they have not been convicted of anything. That is insane. We need to fix that. And the commercial bail system exacerbates that problem. First of all, it is not rational. And I'm going to use the example that Republican Congressman Stubbe said in his opening statement, where a defendant was able to purchase his freedom by posting a $15,000 bail bond, and then he went and killed a law enforcement officer. Yet there are many poor defendants who cannot post that bail, and they're sitting in jail. So it is actually a more dangerous system when we allow wealthy defendants to purchase their ability to get out of jail and then commit more crimes. Money should have nothing to do with an individual's freedom, period. That's why I was glad to have worked with Republican Senator Rand Paul, Democratic Senator Kamala Harris, and others here in the House to have introduced the Bipartisan Pretrial Integrity and Safety Act last term. We're going to reintroduce it this term. It's going to provide grants to local states and jurisdictions to help them with their pretrial detention to move away from money bail. I've also introduced the No Money Bail Act every term I've been here in Congress. And I was also pleased to work with Chair Nadler to secure report language in the fiscal year 20 appropriations bill to ensure that the Bureau of Justice Statistics provides better data on the state of our pretrial population. So I'd like to ask Mr. Buskey and Mrs. Cook about, since you all have extensive bail experience, about some questions in terms of how we're going to provide these grants and some of the conditions we should put on them. So would you, first of all, support the following pretrial practices? Number one, expanding the use of citations instead of custodial arrest.
Yes.
Yes.
All right. Second, would you support that and ensure that before imposing pretrial detention or a condition of release, a hearing takes place within 48 hours?
Yes.
Yes.
Third, requiring representation by counsel for all defendants prior to any hearing at which a defendant's liberty may be determined?
Absolutely.
Yes.
And then finally, providing that any pretrial release conditions are non-financial based on evidence-based practices and are only as restrictive as necessary.
Yes.
Yes.
So I will be reintroducing a modified version of the Bipartisan Pretrial Integrity and Safety Act based on what we've heard from this hearing. And I just want people to look at this issue, right? We in Congress every 2 years vote over 1,000 times. Most of those votes, we don't get a single phone call, email, fax, or meeting. Members of Congress and most American public aren't walking around thinking about bail. We want people to think about bail because it is a massive problem. It is flipping the presumption of innocence on its head. It is irrational, and it is penalizing those who are poor. And studies have shown that the people who cannot afford to purchase their way out of jail are exactly the people that cannot sit there for weeks and months on end. They lose their low-paying job. They don't know how to deal with child support. They can't pay their rent. It's a cascading consequence of more and more bad factors, and it completely wrecks their life. So look forward to working with all of you as we continue to work on this very, very difficult issue. And it is also a bipartisan issue. The state of Kentucky largely has moved away from money bail. Washington, D.C. doesn't do money bail. California just put in a new law. We'll see how that goes. And other states are looking at it. And it's important that we look at what states do. If there's problems, we try and fix it. But I think we do have to give resources to various states to make sure they can implement alternative systems that don't continue to penalize the poor. And with that, I'm going to yield back. Oh, yes, I'll yield to Congressman Richmond.
Let me just add in a short period of time that we have a hybrid of a risk assessment system in New Orleans. The executive director of that risk assessment makes $350,000 a year because it's grants. And I'm not opposed to the salary, but there's better uses of money. And I think that as we look at it, we ought to look at maybe how, as we give out grants, how local jurisdictions can do it in-house, save that money, because all of the criminal justice system is financed on the backs of defendants through fines and fees and other things. And I think we have to take a holistic approach. So I'd love to work with you on that, but I just want to point out that the director of my local risk assessment is in the 300s.
Thank you. Appreciate that point. I'm going to yield back and now recognize Representative Mercarso-Powell for 5 minutes.
Thank you, Mr. Chairman, and thank you to the witnesses for appearing here this morning. I think it's obvious that we need to reform the bail system in America. Cash bail seems to be stuck in an old view of the world. I have to tell you that in Miami-Dade County, there was a study conducted that showed that the jail averages over 2,000 inmates daily, and about 80% of those detained were pretrial inmates. These individuals who can't afford to make bail have been jailed before they have had the opportunity to defend themselves in court. And of course, wealthier individuals don't have these issues. So more importantly, I think that money bail systems have a disproportionately negative impact on minorities and low-income defendants. I represent a district where we are a majority district. Most of the people living in my district are Hispanic, African Americans, and I am very well aware how difficult it is when you are sentenced for a petty crime, you're detained, you don't have a trial, and you have no means to get out of jail. Bail for Black men is on average 35% higher than white men, and bail for Latinos is on average 19% higher. Money bail and pretrial detention often have devastating effects, even if a defendant is not convicted. Pretrial detention throws disadvantaged defendants into a cycle of trauma and hardship that can last for years, which we've heard this morning. It can mean that a defendant loses custody of his or her kids because she can't care for them while awaiting trial. It can mean a person loses his job because he can't get to work while awaiting trial in jail. And it means that these defendants often can't find adequate legal representation while awaiting trial in jail. This approach to our criminal justice system only causes harm to our communities and the people that we are trying to represent. We have to reform the bail system in order to uphold equal justice under the law. And so I want to start with Mr. McElroy. You mentioned that a $500 bail set for you was the same as $1 million for an unemployed homeless teen. Can you explain a little bit what you mean by that, and what are some of the hardships that money bail placed on you or other low-income or unemployed defendants?
Yeah, so this year I've contributed to bailing out about 8,500 people across the nation in 19 cities. You know, I'm reminded of Miss Priscilla, who cried when the judge set $3,500 bail on her. And she's a grandmother, 65 years old, primary custodian of her grandbaby. And she was in jail 7 days before we brought her out. And she lost her job. Her granddaughter slept on people's couches. And the case was dismissed shortly thereafter. And there's no recompense. Nobody says sorry. You know, and this is perpetuated. I'm reminded of an LSU student, I'm sorry that Mr. Richmond's left, who $3,200. She was accused of stealing 2 T-shirts from her roommate, theft over, you know, in the middle of finals. And our staff were able to talk with her professors and procure the opportunity for her to complete her finals, and she's a junior at LSU currently. And I could go on and on, right? Like these are human beings that where my friend mentioned, Miss Mary, that you know, the bail bonds industry would have helped them. The predatory system that takes poor people's money, like Nisha, who I mentioned, who's paying $300 for a case that was dismissed. Did that bail bondsman walk up there and say, oh, your case was dismissed, you don't owe me anymore, here's your $1,500 back? Did the judge put himself in that situation to make sure that she was put back whole? No. So what are we really talking about? We're talking about human beings that the price of their wallet determines how much justice they get, whether they get to participate in their own case or not.
Yeah, and it perpetuates the cycle of poverty in many of our communities and the cycle of injustices and the school to jail pipeline that we see in a lot of our communities. So I agree with you. Thank you so much for being here today and sharing with us your story. I yield back.
Thank you. Before I call on Representative Cohen, I just want to thank you, Mr. McElroy, for the work that the Bail Project does in my district in Venice, California, as well as throughout the country. Representative Cohen, you're recognized for 5 minutes.
Thank you, sir. I'd hope that these questions have not been asked just because I was in transportation. But the federal system is different than most of our states. How does the federal system work in saying that the percentage of people who return are is distinguished from those who flee?
How does it work as far as, are we doing well?
Numbers, yeah, exactly.
Yeah, the numbers are incredible. I mean, we have 99% of people who are released on, this is 2018 numbers, 99% of people released on bond appear in court and do not flee. And interestingly, that rate holds true whether you're looking at the 5 federal districts in this country that have really low release rates, around 20%, or the 5 that have really high release rates, around 80%. So whether we're releasing a lot of people or whether we're releasing very few people, almost nobody's fleeing. And the numbers for danger, meaning reoffense, are pretty much identical at 98% not reoffending.
So the federal system has no bail bondsman, right?
That's correct, technically.
And the bail, what do you mean technically?
Technically, there's a part of the statute that says a financial condition is not supposed to result in the detention of the person. However, there is the allowance for some bail bonds. There's the allowance for money bail. There's the allowance for putting up a home as collateral for your release.
Yeah, but when I say bail bondsman, there's not a professional bail bond system. You put your money up with the court, do you not?
In some federal districts, there are professional bail bondsmen, yes.
Are there?
Mostly they're not, but I have heard of some.
Well, they're often lobbying against any of these reforms. And I know when I was in the state legislature and the state senate, we had tried to get some change of system, and what they ended up doing was they passed a bond origination fee. That may be they do that every other places too, but it was like a basic $35. They said that the low-cost bonds, they couldn't do them at 10%, because I'm going to say $250 bond, it'd be $25 wasn't worth it. So they put on a $35 bond origination fee to make the smaller bonds more workable, efficient for the bail bondsman. Of course, that makes it $60 for the bond, and on a $250 bond, that would make it like 27% or something like that bond. But they put that $35 on every bond, even if it was a $10,000 bond. So it wasn't to make it effective and efficient and merchantable for the bondsman. It was just, turns out it's extra money they put in their pocket. And they lobbied against everything we had, whether it was citations in lieu of arrest in the field or citations in lieu of arrest at the issued in jail when you're arrested. They lobbied against it all, and they got it done. Are there any states that are models for reform?
On the money bail issue, I would defer to the people who are experts on the state money bail problem.
Mr. McElroy or Mr. Buskey?
Yeah, I mean, I would say there's states that are being thoughtful. You know, oftentimes my state, Kentucky, is mentioned, but Kentucky is not a state that doesn't have cash bail. Kentucky is a state that is very dependent on algorithms, and as many people have mentioned, algorithms are only as good as the information that go in them. And I always think about it like this: on any given day, if narcotics wants to do investigations, they can either go to their university or they can go to a low-income community. And we know which one's politically correct. And so when you have absorbent policing and surveillance, you're going to have, out of those communities, higher algorithms that lead to higher risk assessments.
In terms of states, I would say that New Jersey is probably the state that is thinking the hardest and best and doing the best on these issues. As folks may know, New Jersey had very significant reforms about 2 years ago to its pretrial system that was largely based on money, huge bail bond industry, many of the same arguments against reform that we're hearing in the current debate. New Jersey today, according to reports from last year, has virtually eliminated cash bail. And so cash bail is only entered in, I think, less than 1/4% of cases, right? So hundreds out of tens of thousands of cases end up in cash bail. They've seen no change in the rates of rearrest prior to trial. Those still remain less than 1%. There was a slight decrease in court appearance from a very, very high 93% to a still very, very high 89 to 90% reappearance rate. But they also found that even with that slight decrease in appearance rates, that cases were still completing in the same amount of time. So despite all the rhetoric from the bail bond industry, even though people may have missed a court date, they were coming back. And finally, I would say they're doing all of this with astronomical release rates at over 95%. And much of that is due to the fact that New Jersey dramatically increased non-custodial arrests. So many of these folks who are getting out, and I think of upwards of about 30,000 people increased over last year, are never being booked into jail prior to their first court appearance. So I think all of those things are ones that we try to replicate. The one thing that I would point out about New Jersey that does require some caution is that they do use risk assessments to make these determinations. And that's the one thing I would think we want to go back and look through and really determine what role the assessments are playing in deciding detention and release in New Jersey.
Thank you. Thank you. The gentleman's time has expired. This concludes today's hearing. I want to thank our, yes.
Could I ask unanimous consent to submit a letter from Senator Jeff Van Drew, from Bob Andrzejak, regarding the vote they had on their bail system?
Without objection.
Thank you.
So thank you to our distinguished witnesses for attending. Thank you all in the audience for being here. All members will have 5 legislative days to submit additional written questions for the witness or additional materials for the record without objection. The hearing is adjourned.